Hello and welcome. And if it's not too late, a happy new year to you all. My name is Jeremy Glover, and it's my pleasure to introduce our first Fenwick Elliott webinar for 2024. It's traditional to look forward at the beginning of the new year, so we thought we'd ask what the future lies for ADR. We're going to look at a variety of different themes: adjudication, mediation, dispute avoidance. And I'm really pleased to be joined by two highly experienced practitioners. My colleague and fellow partner, Claire King, who comes recommended as a global leader in construction by Who's Who Legal and for international arbitration, the Legal 500. She's also a member of the steering committee overseeing the recent research on adjudication carried out at King's College London. So she's the ideal person to talk us through some of the key findings. We're also delighted to be joined by Edwin Glasgow KC, counsel at 39 Essex Chambers. He almost needs no introduction. Indeed, Chambers have referred to him as something of a legend in his own lifetime. Among his many attributes spanning a career of more than 50 years, what is important for today is that Edwin has acquired extensive experience as a successful mediator. He's known for having a hands-on style, which has helped him successfully settle about 90% of the many hundreds of mediations in which he's been appointed, both domestically in the UK and internationally. He was the founding chairman of the Singapore International Mediation Centre, and for the purposes of today, he was one of the counsel asked by CEDA and the CIR and the Civil Mediation Council to act as intervener in the Churchill case, which came before the Court of Appeal late last year. Edwin will be explaining for us why that was so important. So just a reminder for everyone, you're all on mute, but please do send in any questions. You should also find the slides on our website later in the week, and a link will be put on the chat during the webinar. But as a starting question, why ADR? And what is ADR? Now, I think the focus there is the word alternative, because ADR comes in many different forms. You can see from the examples that we've listed on the screen, it's a wide variety of very different things. Negotiation, that could be sitting across the table with the opposite number. Mediation, much more formal. Adjudication, there's a process, a 28-day, 42-day process. Once upon a time, arbitration was thought about as an alternative form of dispute resolution, but I think today that's not right. I mean, the problem with arbitration, the way you want to avoid arbitration, the way you want to avoid litigation before the courts, they both can be very costly, and they both can last for a very long time. So why ADR? Why now? I think that what we need to be doing, I think that what everyone should be always doing when they're working with disputes is looking at alternatives to protracted court proceedings. That's always a good thing. And there have been a number of recent developments which we'll all be able to talk about, which help in that regard. And you just need to remember to be flexible. It's important to be prepared to be flexible. Think about what's right for you, what's right for your project. But what you need to be looking to do is to be able to step away from the litigation mindset, from the litigation carousel. I mean, it's not always an easy task. As it was once said, that litigation is like dancing with a gorilla. You only stop when the gorilla wants to stop. Now, of course, sometimes the trick is avoiding beginning the dance in the first place. And certainly one of the topics that we'll be considering later today is how to avoid ending up being locked in the embrace of the litigation process. But in fact, that's something that adjudication can be a vehicle for. So over to Claire.
Thank you very much, Jeremy. So I'm going to talk about the King's College Report on Adjudication 2023. This was the second King's College Report on Adjudication in practice, following on from the very well publicised one last year, and it's finding that I think it's 7.88% of adjudicators were female, and a lot of press on that particular finding. So this year's one was authored again by Professor Nazini of King's College and Alexander Kullitz. It was guided by a steering group, which I had the pleasure of sitting on, and sponsored by the Adjudication Society. And it was launched at the end of November at the Adjudication Society's annual conference. Questionnaires were issued to all the AMBs. 9 of those, all the major ones, responded. And there were also questionnaires distributed widely to individuals. Some 44 adjudicators responded to give their findings on the various questions, and 158 respondents overall. So what were the findings? I'll go through the key ones as I see them to start with, and then have a look about where it might be pointing to in terms of projects on adjudication perhaps for this year. Well, referrals, as it says in the report, or rather requests to appoint adjudicators, have oscillated around 2,000 per year for the last 5 years. And as Mrs. Justice O'Farrell highlights in the introduction, the forward to the report, that is more than all the cases in the TCC and the commercial court combined. It had gone up as well by 9% last year, and I'm not sure what that says about trends, but I suspect that could be linked to the economic situation we find ourselves in currently. There are no statistics on, obviously, the number of disputes referred where parties agree the adjudicator, and that is done fairly frequently for experienced practitioners anyway. And there's no data on the number of requests for appointments that don't result in an adjudication or a final referral notice after the appointment notice. But overall, there's a trend around 2,000 per year the last 5 years, and an increase of 9% in the last year. So one of the most interesting things I found was what generates disputes, because if you have a look generally in construction, there isn't that much underlying data on what actually causes a dispute. There's the odd report every sort of other year, and this is focused obviously on domestic adjudication. But as you can see from the data, construction management is firmly in the frame for these types of adjudication reports anyway. 48% of disputes result from a lack of competence of the project participants, and 42% was inadequate contract administration. So that's a huge amount of disputes being generated by paperwork and by people not managing or perceived not to manage projects properly. And I know there's been a lot of commentary on that press and what that says about the need to train up project managers and get that contract administration in progress. 32% was changes by client and 30% exaggerated claims. So some interesting data there on what actually causes the need for ADR and court and arbitration in the first place. So types of disputes referred to adjudication. Now there's a new category that we introduced this year called the smash and grab, which most of you who are adjudication practitioners will obviously be very familiar with. We wanted to separate out that from sort of account disputes generally as a new category, because it's obviously very distinctive. It's based on you not issuing your paperwork properly again. And that is huge, 63%. With the most common category of claim. So that obviously raises again questions about why people are not issuing their notices in time, or their pay less notices in time, given how long the Act has now, in its current form, has now been in effect for. Underneath that is true value disputes on the final account, followed by loss and expense or damages for delay or disruption, and then true value on interim payments. So the interim disputes are a little bit less common than final accounts, but not that much really if you have a look at the statistics. So in terms of value of the disputes referred, there is a wide range. The most common, so 45% of adjudications, was in the range of 125,000 to 500,000. But there are some very high value adjudications as well, and we're certainly used to dealing with those as well. The highest value identified was between 30 and 40 million, and that's 1% of the disputes referred. So parties are using adjudication for high value disputes, not just low value ones, although 3% of claims fall for under 25,000 as well. And I think it's interesting looking at that. I was rereading St Mary's report on arbitration in the context of construction, and noted that I think in-house counsel was saying that they wouldn't start an arbitration if it was under 10 million, or they'd be wary of it. So there's obviously an overlap between arbitration and adjudication for a category of value of these claims. In terms of fees, there's a sort of, the most common range is between 20 to 30,000 for an adjudicated charge for resolving a dispute. But we've got sort of another clump at the lower end, sort of 4,000 upwards. And typical hourly rates, slightly lower than you obviously would expect for arbitrators, but the most common category is 301 to 350. So interesting to know that when you're deciding whether you're going to appoint somebody or not. So the data shows that adjudication is very effective at finally resolving disputes. It settles the vast majority of the cases that have gone through the adjudication process. So just looking at those stats, less than 5% of cases go on, I think in 21% of the cases, and there are no other proceedings at all in 42% of the cases. So very often it's a one-stop shop for resolving those disputes. In terms of how it's working as a process, the data shows there's negligible complaints made about adjudicators to the AMBs. RICS, who have, in fairness, the most appointments made, had 20 complaints only last year and 2 were upheld. Ariba only had 2 complaints, and again, none were upheld. And enforcement rates are equally high. If you get an adjudication decision, it's very rare that it will not be enforced, although natural justice and jurisdiction arguments are still around, obviously. So that all paints a very positive picture. And as Mrs. Justice O'Farrell says in the opening, sort of potentially lays open the door to expanding adjudication, or the argument for expanding adjudication into other areas. So suggestions maybe they use for technology disputes, professional negligence disputes, telecoms, airline disputes. And as she says, there is a strong argument for extending adjudications to all forms of construction operations and indeed other areas. So construction operations at the moment, we've obviously got the carve-outs under the Housing Grants Act, which would be in place right from the beginning, especially in relation to energy and power projects, for example, that maybe this arguably suggests should be revisited. So that obviously paints a very positive picture, but there was one statistic in here that follows up on one that was of concern to Lord Justice Coulson last year, which is of perceived bias. And I should emphasise here that we are not talking about objectively proved bias, we are talking about perceived bias, which is very individual. Last year, the stats was that 40% of those parties involved in an adjudication had suspected bias of some form or the other since they've been involved with adjudication. And quite rightly, we've now limited that question to the last year and asked, have you ever suspected it in at least one case you're involved with in the past year? And the statistic was still quite high. It was at 27%, which I think is too high. And I know some firms, don't necessarily perceive the lack of complaints to AMBs as necessarily being a good thing, and that there's a feeling that maybe you don't want to make a complaint unless it's very, very egregious behaviour. So there's something going on potentially behind the scenes there that needs to be explored further. And the main cause of that perceived bias was the adjudicator's relationship with parties or party representatives. That seems to be by far the highest reason for accepting that. There is, I think, again, as Justice Farrell points out, is generally perceived to be a very easy way of dealing with that, potentially. And I think that's something that the Adjudication Society and King's are looking at this year. And that is whether we need a code of practice that makes it clear that an adjudicator has to declare any conflicts, not just to the AMB, which sometimes aren't passed on to the parties, but also to the parties right at the beginning. So you've got that sort of transparency, and whether there could be a code of practice for adjudicators about potential conflicts or relationships in the same way there is for arbitrators. So that's something I think could be looked at in the next year. The other, obviously, thing we're continuing is the diversity of adjudicators. Last year we had a big push. We launched Women in Adjudication. We launched the pledge for equal representation in adjudication with Lady Justice Carr. So it's really next year's task is to try and get more statistics on all forms of diversity in adjudication, so that we can really try and drive that change forward. Although I know a lot of A&Bs have, as a result of the pledge, already made some very positive changes to their appointment processes, which is great. So with that, I will hand over to Edwin on mediation.
Yes, you will do as soon as I found my mute button. I think I've done it. Thank you so much. I learned a huge amount there. I've been asked to just have a word about the Churchill case, which Jeremy kindly noticed. For those who don't know, Churchill, the case was actually all about claims against Merthyr Tydfil Council for the spread of Japanese knotweed. And fascinating though that was, the only reason anybody paid any attention to the case was that the Borough District Judge felt that although this was obviously a claim that should have been dealt with under effectively a free council ADR scheme, the decision in Halsey 20 years ago had prevented him from making the order that he plainly wanted to make and said he would have made, which was to order mediation and stay the proceedings until they'd had a crack at it. Now, I think we all need to remember that the actual decision in Halsey, John Dyson and Alan Ward, almost exactly 20 years ago, was absolutely right. Lawyers and sometimes their clients who behave obstructively and refuse to even attempt mediation should be penalized in costs, even if they ultimately win. That is what Halsey actually decided and got 100% right, and nobody's ever disputed that. It is, I think, sad and unfair that the only bit in Halsey that went too far was an added comment, if you want to go into Latin and obiter dicta, but it's just an added comment that wasn't necessary, that Article 6 of the European Convention might prevent a court from actually ordering a party to engage in mediation, because that would theoretically be a bar to access to justice. That was, of course, the sort of gibberish that you'd expect from the European Convention. Nobody paid any attention to it, but it was rather a shame that it was a silly mistake. It was pressed onto the court without any notice and without any warning to any of the parties by a rather over-enthusiastic European law specialist who made his mark by saying it. But it was a little mistake that was so obvious that even I was able to persuade the Court of Appeal. They dragged me out of retirement. I hadn't done a case for 12 years, but CEDA and the Institute asked me to go back and argue it as an intervener. And even I succeeded in persuading the court that it was wrong and it was unnecessary, and there was absolutely no reason why a court should not, in an appropriate case, more of that later, order parties to try mediation in exactly the same way as they order a lot of other things. They can order deposits for costs. They can order experts to do things. It's not a bar to access to justice to order something that is obviously necessary and essential. So the position now is, at last, after 20 years, that a court can, in appropriate cases, direct parties to mediate. That, I think, is particularly important in construction cases and for construction lawyers. It's good news for both the lawyers and the clients. There are, in my experience, which is Jeremy kindly reminded me is rather long, and I'm way past my sell-by date, I appreciate that. But in those over half a century, I think I came to the firm view that there are two types of lawyers and probably two types of clients. There are lawyers who put the firm's interests first and those who put their clients' interests first. And there are clients whose principle is, if in doubt, sue, and clients, particularly on the construction side, who say litigation is the very last resort that we ought to be engaging in. And it's because of those two contrasting views that I think that Halsey is very important. And that principle or those differences apply, in my experience, particularly to construction work. Because most, if not all, of the good, the decent construction law firms actually do put their clients' interests first. They don't get hung up with maximizing the fee income on a particular case. They want to look after the client in the long term. I'm not suggesting that that's sanctimonious altruism on the part of law firms. I don't suppose it is, even in the case of Fennig Elliott. But my experience of them and the other decent firms is they care more about the long-standing relationship with the client than making a quick buck on the fees in a big case. Because, of course, mediation does deprive the lawyers of a certain amount of fees. Nothing like as much as people would pretend, or its opponents would pretend, because if mediation is engaged in, it's only worth doing if it's properly done. And if it's properly done, it does require quite a lot of cost in proper preparation, proper consideration, proper documentation, presenting a decent case. And if in the unlikely event mediation fails, of course, none of that expense is actually wasted, because it's all going to be used, or the vast amount of it, if in fact the arbitration or the case has to go ahead despite the mediation. And turning and looking at the client for a moment, and I think that many of you are people interested on the actual construction side more than the litigation side. The good construction firms, in my experience, are the ones who are more interested in constructing things than suing people. And I think we all know, we won't mention any names, but there are some construction firms who've simply got a name for litigating. The law reports are cluttered with all of their names. They bring cases at the drop of a hat. And there are those very good firms who you almost never see in the law reports. And I think that is because they and the lawyers who represent them encourage them to look at litigation as being a last resort. And what about mediators? I think that the curse on mediation is, in fact, that a vast number of unemployable lawyers get jobs as unemployable mediators. And that's very sad, because we all know that there are some mediators who one shouldn't let mediate one across the road. If you're going to go for mediation, you do need somebody who is actually going to take the case seriously and do it seriously. It isn't just a cheap alternative that you can go along to somebody and chat about it in an informal way and hope that in some way he will encourage amity and friendship to break out. If you take the job seriously and mediate, and it's only worth doing if you do, you take the case equally as seriously as if you were arbitrating, or even as if you were preparing as counsel. You prepare just as thoroughly. You examine the principles and the difficulties, and you confront people with the problems in their own case. Otherwise, mediation is not worth doing. Anyway, the importance, though, I think, and this is where Jeremy, I'm about to hand back to him, the importance of the Churchill decision is that at last, that clog on the mediation, not just mediation, on all of ADR. It's all a suite of solutions in dispute resolution. It doesn't matter what you call it. Adjudication, as Claire's just said, is equally important, and at the bottom end, hugely important in the way in which disputes are resolved. But what really matters is that the good law firms and the good construction firms can now rejoice in the fact that nobody can refuse to engage in an alternative dispute procedure where it is appropriate. And I believe, in my experience, that courts are going to, in future, the default position will be to direct and order mediation, to make it effective by a stay, which you can perfectly properly do in exactly the same way as if anybody broke the rules in any other procedural order. If you don't produce your experts to court on time, you don't give security of costs, you refuse to participate in the discovery exercise. Courts and arbitrators have always had the position in which they can effectively stay things until you've done what you ought to do. And I think in future, Jeremy might agree that we're going to have cases in which you will find it much easier to persuade a court that it's a complete waste of money to engage in the full pursuit of either arbitration or litigation before you've even given the chance for mediation to take place. And I think the only additional point I'd make is that for those, and I'm sure there'll be some of you who say, well, it's a waste of time, you can't mediate against people who don't want to. Forcing people to mediate will mean that they'll just go through the motions and they'll turn up. May I just say what I said to the Court of Appeal? After many, many years and many hundreds of mediations, I am quite used to people being told that they wouldn't engage in mediation because they don't like it. And I do say, I think it's a little bit like trying to feed my grandchildren. One is used to being told as a grandfather that I don't need to try tomatoes. I know I wouldn't like them. And the odd thing is, you know, when in fact you make your grandchildren have a go at tasting tomatoes, quite often they don't dislike them as much as they thought that they would. And the people who say, I don't want to mediate, for the vast majority of them have never tried it. And when they do, even when they've been compelled to do it, it is quite surprising and rewarding. The number who then say and shake you by the hand as they leave, that's nothing like as bad as I thought it was going to be. I'm so glad we did it. Thank you very much. My prejudices are overborne, but there we are. That's a personal insight. Jeremy, I hand back to you because I'm sure there'll be one or two questions. That's really the only contribution that I felt able to make.
Okay, no, thank you very much, Edwin. And I think your final point is a really important one. You do get this reluctance for parties to mediate, and it's only when you try the process that you realise that it actually can be quite effective. And a number of different reasons or different ways you can do things, but actually being able to, and sometimes the way to settle these cases is to actually move away from the matters in dispute and see what the overall long-term commercial decisions and realities actually are. But I think you're right, and thank you very much, Edwin. The importance of the Churchill case is that there's going to be much firmer encouragement or ordering of the courts to engage in mediation. And one of the key questions, one of the things to be thinking about is, well, when is the right time to actually mediate? And if you really want to look to the future, we badge this as looking into the future into 2024. I think the key words personally you need to be thinking about are dispute avoidance. Now, when Claire talks about adjudication and Edwin talks about mediation, particularly if the court has directed you to mediate, there must already be a dispute. Now, if we're really looking to the future, the path that we should perhaps be following is looking at questions of dispute avoidance. And one of the excellent ways that you can practice dispute avoidance is working particularly, and this only applies to the much larger construction projects, it's working with dispute boards. Now, for those of you who don't know, a dispute board, standing body, typically, ideally set up at the beginning of a project. It's a body of one or perhaps 3 people, and there'll be construction professionals. So could be lawyers, could be engineers, could be QS, could be consultants, designers. You want a mix of skills. They're there to help parties avoid or overcome any disagreements or disputes that arise during the implementation of the contract. That's the ICC dispute board rules. It's quite a flexible definition. They're there to assist parties avoid and overcome disagreements. And that's the basic idea when you have the sort of the FIDIC form of contracts. The original version of the FIDIC Rainbow Suite, they talked about dispute board members being independent with the ability and freedom to act impartially, develop a spirit of teamwork within the DAB, make fair, unanimous decisions. Now, one of the things that the original Rainbow Suite dispute boards were doing, they were there primarily, there were referrals and there were decisions. But there was also the opportunity for the dispute boards, and it was there in the original 1999 contract suite, for the dispute boards to act in a sort of dispute avoidance way. So if the parties agreed to see what alternative options there were without there being this formal referral. And FIDIC recognised this in the 2nd edition of the Rainbow Suite of contracts, and the DAB rules, they changed the name. It's now the Dispute Avoidance and Adjudication Board. And dispute boards are there to facilitate the avoidance of disputes that might arise. They're also there to achieve cost-effective resolution of any dispute that might arise. And the stats for dispute boards being able to do that, very similar to the stats that Claire was talking about when it comes to the success of domestic UK adjudication in producing a final answer without the need to go to the courts. If anything, the DAB figures are a little bit better. But you have this idea of sort of the dispute boards, this concept for dispute avoidance. And they also can practice in dispute resolution as well. But you resolve the disputes within people who are familiar with the project. You don't want to end up at the end of a project going off to international arbitration, sort of, 2-3 years. That's not good for anyone. And the great thing about the dispute board is they're there from day one. They know the people, they know the projects, they're familiar with the issues that are evolving. So a good dispute board, particularly when they're tasked with the encouragement in the contract that you find in the FIDIC 2017 suite, they're looking to see where the issues are, what's bubbling under, where might the disputes arise. And if you've got the right set of experienced construction professionals, they can see where trouble might be brewing. And then if they go to site, which they might do every 3 or 4 months, they can perhaps work with the parties to look for ways to just, quietly stamp down on what might be festering. And that's sort of dispute avoidance, is being able to recognise where issues might emerge. And FIDIC very helpfully, and this came out at the end of November last year, they produced a dispute avoidance practice note that focuses on dispute boards, and it's there to help promote dispute avoidance. It's there to try and help parties avoid ending up in the formal referral of disputes. And there were 5 key points that you can see that FIDIC were looking for the dispute boards to address. Now, this is specifically for dispute boards, but I think those 5 questions probably, they relate quite easily and very well to any construction project. If you're thinking about dispute avoidance, you're thinking about setting up processes and procedures so you don't end up in a formal dispute. Well, these are some of the questions that I think that you need to be thinking about, you need to be addressing, and answering the questions. Well, everyone's going to have their own different answer to those questions, but one thing a dispute board should do is make parties aware of its dispute avoidance role as early as possible in an introductory meeting. Now, there's no, you can actually think about that on any type of project. Well, maybe, things are good at the onset of a project. You can set up processes. You can think about how you want to be sort of running all of your projects. When it comes to dispute avoidance, FIDIC talk about consensual approach. They're looking for a joint request made by the parties. And that's fair enough, because you need these things to be agreed at the outset by the parties. But the dispute board, they can be proactive. They can promote or suggest issues that might be ripe for resolution through some form of dispute avoidance technique. You need the parties to be present. I mean, there's a lot of talk, that you do have virtual meetings. You can have virtual mediation that can be successful, but nothing beats being physically present. So the best way is it's talking. It's all about communication. If you want to be avoiding disputes in the first place, you want to be communicating with each other, whether or not you've actually got an alternative sort of dispute board present. What are the type of matters that lend themselves to dispute avoidance? Well, you need to be thinking about, if that question is answered, will that unlock the stalemate? Will that bring an end to the impasse? Will that actually just enable the parties to move on? So quite often it's like, well, what does that part of the contract mean? What does those key 6 words on that particular drawing, what do they actually mean? And when we talk about dispute avoidance, you're not asking necessarily the dispute board to make a formal decision like a UK adjudicator might do. You're asking them maybe to give their opinion. They might make a recommendation. And sometimes that's easier for companies, employers, owners, local councils to deal with. Well, we've got this bunch of construction experts. Their view on that issue is this. So if we proceed to court, that's likely to be the outcome. Then it's much easier sometimes to get an overall resolution to the process. The right techniques for dispute avoidance, it's talking, informal discussions. Sometimes, I've said there, we've got there, FIDIC have said, you issue an opinion. The strict wording in the current FIDIC contract is, if the parties agree, they jointly request the DAB to provide assistance and or informally discuss and attempt to resolve any issue or disagreement that may have been arisen. Now, that's not asking, so dispute board doesn't necessarily have to write, we'll listen to what the parties say, we'll give you a recommendation, we'll give you an informal decision. Sometimes just discussing the issue enables the parties to understand better the reasons why the other party have taken the position they have, and perhaps better the potential weaknesses in the position that they have adopted. And that all helps facilitate a settlement. I mean, you can have a site meeting, you can discuss the issues, the dispute board goes away, they never hear about that issue again, because the parties have had the chance to air their frustrations and they've been able to come up with a solution to the problem. So I think, we're looking to the future. Concepts of dispute avoidance are incredibly important, and that's recognised domestically in the UK. We have the government, the construction playbook, government guidance on contracting public works. You'll see that the construction playbook endorses dispute avoidance boards as a potential way to avoid and manage disputes. But I also just briefly wanted to mention something else that the construction playbook does endorse, and that's the conflict avoidance pledge. Commitment to conflict avoidance, use of amicable resolution procedures to deal with emerging disputes at an early stage. There's this idea, again, not letting parties actually get to the stage where there is actually a dispute. And the construction avoidance pledge is something that's been developed by a coalition of professional and industry bodies. And it's the idea of this commitment to conflict avoidance, and it's encouraging parties to contract to think about what's the best way, what's the best mechanisms in their particular contract form to sort of set up, see how can you resolve problems before they escalate into disputes. Now, if you remember the slide right at the beginning of this talk, it's a whole host of different processes and procedures that people can think about, but it's all about these new ideas of sort of working collaboratively, looking for early intervention techniques. They all help reduce costs, and they all support the idea of, as Edwin was saying, you know, all we're interested in is getting these projects built on time and on budget. And so with the construction avoidance pledge, you've got this conflict avoidance toolkit. And it actually asks you to think about the pre-contract stage. Think about your project documentation. Claire was talking about all the disputes that are emerging because people don't understand the contracts. People aren't able to run the contracts. Think at the first step, thorough preparation of project documentation. Think about the risk allocation in your contracts. But that's the very first step about avoiding disputes. Set things up as thoroughly as you can. Think about early warning systems. Think about procedures that allows for early intervention. Then you can, if those aren't working, then you can think about the more mediative methods helping to resolve disputes, you know, in a way that's private and not adversarial, not in the courts, not in arbitration. If you do go to dispute resolution, well, are there alternatives that can get a quicker and cheaper result than courts and arbitration? That's where perhaps adjudication might come in. So you do have, and it all accumulates in this idea of the conflict avoidance pledge, and you can find more details of that by just sort of zooming in on the various QR code. But wanted to talk about the future of ADR, and it might not be the future of ADR quite in 2024, but if we are talking about the future of ADR, I think it all starts with conflict avoidance. Dispute boards are a great way to do that, but you don't have to have the biggest project to be thinking about the concept of conflict avoidance. So I think those are the issues that we were hoping to discuss with you today. And it's more like just to highlight things, highlight what's been happening, highlight what's been going on in the world of adjudication, which, as we all know, has completely transformed the way construction disputes are dealt with in the country, to reinforce the importance of mediation. The TCC has always been very good at encouraging parties to mediate at a very early stage in the disputes. It's there, I think, quite often in the pre-trial questionnaires. You need to actually think about it. But the importance of the Churchill case and the interventions that were coming in from CEDA and the CAR, and now the courts can actually take that more final decisive step to order mediation, and then look into the future about to what might alternative ways there are. It's just incredibly important. And if, you know, we'll look to see what can be done. So like I say, that's what the issues that we wanted to discuss. I'm sort of pleased to see that some questions have come in. And Edwin, there's a couple that have come in that directly solely relate to mediation. When would the court order mediation? What circumstances? I mean, was there guidance from the Court of Appeal, or in your experience, when should a court be ordering mediation?
It's a really important and relevant question, and I'm sorry to duck it, but I'm afraid the only truthful answer is that it will depend upon each case. And the Court of Appeal made that plain, at least during argument with us, and I think it comes out of the Master of the Royal's judgment as well. It really does. There is an enormous range. I think probably the right way of approaching it is, I think the default position of courts, and we're going right the way down to district judges in county courts, the default position will be to order mediation. I think it will be the exceptional case where a party is able, for a respectable reason, to say there is an issue of principle here that we really need a court decision on. This is a matter which affects a large number of people. This is a local authority or a government matter in which a public money is at stake. There are cases, there will always be cases, although I believe they are relatively few, in which ADR and mediation is not appropriate. There are cases involving principal and large sums. I think they're relatively few. And let's all start with goodwill. Let's work on the assumption, as the Court of Appeal did, that in future the default position will be, where they're appropriate, parties should, and if they refuse, are capable of being ordered to mediate, unless there is a very good reason why not.
Okay, no, thank you. Yeah, I recall, as soon as you mentioned it, the Court of Appeal had deliberately not said when they would, what the right circumstances were. I mean, do you think that it's right, perhaps particularly when you're talking about construction disputes, so the court should be looking to mandate mediation early on in dispute?
That's another issue, and I agree with it. From what I've said about the construction, I believe that in all of my experience, I don't have ever come across a single construction dispute that oughtn't to have been resolved by some form of ADR. And I go right back to the original Wembley Arena case, which I was involved in, which sadly they turned down mediation at a very early stage. There just aren't any construction disputes. They don't involve matters of principle in which there's been gross dishonesty and it's important to have a judgment. Construction, the real default position, they should always be ADR'd and probably mediated whenever is appropriate. Okay,
no, that's great. Thank you very much. Claire, there have been a couple of questions about the King's research. What steps would you like to see to rectify the findings there have been about bias in the adjudication survey?
I think I agree with Mrs. Justice O'Farrell. If there's one code in place and everybody knows the rules, and if you have to declare things openly, I think that will help a lot. I know that some A and Bs do it behind the scenes, but then the parties may not know what's come out or have their input on that, or a chance to even know that it's happened. It's not always clear. Conflict checks being carried out by adjudicators and coming to light a week into the process is too late. And I think it will help, which we've had recently, will just focus people's minds and hopefully just be more transparent to everyone.
Okay. There's a question about whether the research has done any, or whether there has been any research or questions yet about the linking the cost of the adjudicator against the value of the dispute, sort of percentage-wise.
No, not yet. I think that's one of those ones where, because it's mainly on questionnaires, it would be quite hard to link it. But it's a good question, and I will discuss it with the steering group. We're meeting later this week, I think. So it's something we maybe perhaps need to look at more. Because in my experience, they're not always linked. Not always.
Okay, no, that's all good. And there've been a couple of questions for me about dispute boards. There's been 2 or 3 questions about what value you think a project needs to be before it's worth considering there to be a dispute board. It's a good question. FIDIC have said a project with a value of about $10 million US, so it's quite a large size project. There's been another question of noting, of course, that FIDIC isn't very common in the UK, which is right. And how can dispute boards be embraced in the UK other than through the project procurement? Well, there's a couple of ways that you can some of the standard forms of contract. The JCT recently, either last year or the year before, introduced their own dispute boards, and they were quite carefully drafted, because one of the issues with dispute boards in the UK is how the dispute board cuts across the statutory right to adjudicate, and the JCT CAR rules were specifically designed to deal with that, so that dispute board would have the function to act as a UK adjudicator as well. So one of the ways I think the best ways in the UK would be to perhaps have a look to see how the JCT have tackled that question. Because even if you had a straight FIDIC contract with a dispute board, and there are a number of projects in the UK, Forth Bridge, for example, where they do use the FIDIC form of contract. But certainly looking to see what the JCT have done would be a good point. And I hesitate here because I smiled when the question came in, because I'm not entirely sure of the answer myself, but it's a great question. The NEC provide for dispute boards. I think these are for projects where the UK adjudication legislation doesn't provide, but the NEC provide for potential disputes to be dealt with by a dispute avoidance board. And the question has come in is, what is a potential dispute as opposed to what is an actual dispute? And I smiled because it's a great question, and I smiled because I don't know myself necessarily what the answer is, but I think it's valuable raising it because it's something that people need to be thinking about. It's not defined, as far as I'm aware, in the NEC guidance note. But what I think they mean, and that's why I think it's relevant to what we're talking about today, is that it's all linked into this idea of conflict avoidance. In the NEC form, I think it's right that DAB is tasked with proactively identifying those potential disputes, and that all comes back to the idea and concept of dispute avoidance and conflict avoidance that I've been talking about. If the dispute board can actually see, well, there's potential disputes brewing, then there's an option for the DAB to be perhaps being proactive in trying to raise those disputes. Edwin.
Jeremy, may I just add a word to that? I think it's really important. You're right, it's a brilliant question. I think it really matters. If DABs are doing their job properly, they quite often spot potential disputes before the parties do. And it is essential that they be given the encouragement to do that. I confess my experience is limited to one case, so it's vastly helpful to everybody to know about that. My one case was the construction of a huge international airport, in which I was, for some reason, I could never understand, and nobody else could, why I was appointed to the DAB. But we decided right at the outset that the yellow FIDIC book was really pretty unhelpful on DABs, certainly at that time, because of course you can sidestep the result. You simply have to have a notice of dissatisfaction and the DAB decision is neutralized. So it's a complete waste of time. What we did in that case was we agreed at our first meeting that the DAB would sit as a mediation panel as well. And that in the event of there being a problem that we spotted, we'd do our best to come to a conclusion. We would have the parties to the meeting. We would attempt to mediate it. But contrary to clause 20 of FIDIC Gold Book, which we struck out and signed in the contract, the decision after the mediation of the DAB board would be respected by the parties for the length of the contract. And the idea of breaking away and doing an arbitration in the middle of the contract was put an end to. And the result was that that airport was concluded on time, on budget, and not one of the DAB's mediated decisions was questioned. And it is my only case, but I did think it was worthwhile because it shows how effective a DAB can be if it behaves as a mediator and if it spots problems in advance, which even the parties sometimes are so tightly bound up in their own field and area that they don't even see them. One of the decisions in that case, incidentally, the first thing we spotted was that the two airports, the international airport was being built beside the domestic one, as is always the case, and they weren't even at the same level. And the parties hadn't noticed that until the DEB tripped over something and said, hang on, shouldn't these floors be at the same level? And we did the drawings, put it right. DABs, as you pointed out, can be hugely effective, provided they're allowed to give effective decisions, not immediately neutralized by a notice of dispute, as provided for in the Yellow Book.
Yeah, I mean that's a fantastic example. And I think, to be fair to FIDIC, the way that the contracts have progressed from the contract you were probably looking at to the more recent one is to put much bigger onus on the Dispute Avoidance Board acting exactly in the way that you have described. And the stats for dispute boards are very much that where you have a dispute board, and that's very rare, that it's much rarer that you actually go on to these sort of full-blown arbitrations. I'm sorry that we're just about coming to an end here. We're running out of time, but hopefully it's just, I mean, well, I don't know if it's a quick question of Edwin, a final one on mediation. Do you think there need to be more mediators, more people trained to be mediators in light of the Churchill decision? Is there a danger that there's going to be a whole series of inexperienced or practitioners with the wrong experience becoming mediators and then giving mediation a bad name?
I think mediation already has a bad name because of a large number of incompetent mediators. I think increasing the number isn't going to help. I think increasing the quality of training and improving the good ones is. That's the solution, not simply having more.
Okay, no, that makes perfect sense. So just leaves me to thank Claire and thank Edwin very much, and thank you for your questions. Hope this has been an informative debate, and just watch this space to see where we go with ADR through 2024 into the future. And talking of watch this space, another of our QR codes. Our next webinar will be in February, and we'll give you all details of that as soon as we can. But for now, thank you all very much for attending. Hope you all have a wonderful 2024. Thank you very much, and goodbye.